As with government at the state level in Texas, one of the characteristics of county government is a multiplicity of elected government officials. Some argue that the large number of public officials at the county level is desirable because it creates a strong system of checks and balances, allowing no one official to dominate county government. However, that system of checks and balances comes at a high price. There are problems of coordination of governmental activity, much as at the state level. One of the most important bodies of county elected officials is the County Commissioners Court, which is the main governing unit in the county. Although the County Commissioners Court is not really a judicial court, it may have gotten its name from the Republic of Texas Constitution, in which the county governing unit consisted of the Chief Justice of the County Court and the Justices of the Peace within the county. The current structure of the County Commissioners Courts in each of Texas's 254 counties consists of a county judge and 4 commissioners. The county judge is elected countywide and serves for 4 years. He or she presides over the meetings of the Commissioners Court and has administrative powers as well as judicial powers in rural counties. In rural counties, the county judge hears minor criminal cases and handles some civil matters such as probate. In larger counties, the county judge is an administrator only, with the judicial duties of the office removed by the creation of judgeships, such as probate judgeships and county court at law judgeships. Each commissioner's court also has 4 county commissioners. Each of these officials is elected from a precinct that encompasses roughly 1/4 the population of the county. In the late 1960s, one of the great issues in constitutional law involved the issue of malapportionment, the allegation that election districts did not represent equal population groupings. The malapportionment of Texas's county commissioners' courts became an important case before the United States Supreme Court because those precincts tended to be drawn to represent fairly equal land areas rather than equal population groupings. In Avery versus Midland County, a 1968 case, the U.S. Supreme Court held that the principle of one person, one vote applies to commissioners' courts just as it applies to legislative districts. The result was that commissioners' precincts must now be drawn to reflect equal population groupings within counties. The main duty of county commissioners is the construction and maintenance of roads and bridges. Usually, each commissioner provides for road work within his or her precinct. That aspect of a commissioner's work is, of course, very important to rural residents. It can be politically controversial and has sometimes been tinged with corruption. The Commissioners Court also sets the county tax rate and the county budget. Related to its taxing and budgeting powers is its power to make contracts and pay bills. Perhaps the most important expenditure of most county commissioners' courts, other than roads and bridge expenditures, is the cost of building and maintaining county jails. Indigent health care can be a significant cost for counties as well, along with, in some cases, fire protection and sanitation. Some counties also have costs associated with the maintenance of libraries and hospitals and costs for emergency welfare expenditures, such as those brought on by natural disasters or fires. The Commissioners Court can appoint certain county officials, and it can hire personnel as well as fill vacancies in county offices. It also administers elections in the county. However, there are numerous elected officials in Texas counties, each with an independent power base. It seems nearly inevitable that tensions would develop between the budgetary powers of the Commissioners' Courts and the needs and desires of other elected county officials. Some county office holders are elected at the county level and others at the precinct level. There is some variation in the numbers of office holders depending on the county. For example, larger counties will have more justices of the peace and more constables than smaller ones. In some counties, constables serve legal papers, while in others, constables also have a law enforcement role with the authority to patrol, give tickets, and make arrests. Some counties use constables to check on truants from school, having found a niche area that others in law enforcement do not seem to want. Larger counties may have probate judges, numerous district courts, and county court and law judges. Some counties may not have probate judges or even county court at law judges. Some of the smaller counties may share district judges and district attorneys with other counties. Laws setting up different offices often vary from county to county as well. As a result, some counties have county attorneys and district attorneys. Others have criminal district attorneys that combine the county attorney and district attorney offices. Some counties have county clerks and district clerks. Smaller counties may combine the offices in one person. Some counties have county treasurers. Others do not have such an office.